All rise. The Honorable Justice of the Supreme Court from recess is now seen. Please be seated. That chair, so I have to stand up. I'm sorry. Format and the chair are not aligned. So with that, I will ask Mr. Shima to please recall the case that was left over from our 9 o'clock docket that we didn't quite reach, and the rest of the morning docket. Mr. Shima.
The final two cases for Friday, February 3rd, 2023 are as follows. First case, appeal number 125781 in the matter of Robert R. Lang Jr., attorney action and original action and attorney discipline.
Good morning, Madam Chief Justice. May it please the court. Julia Hart, Deputy Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator, present and ready for argument. And I would request 3 minutes rebuttal.
3 minutes is granted. Thank you, sir.
Robert R. Lang Jr., pro se.
Second case, appeal number 122418, State of Kansas versus Justin W. Steinert, Sedgwick County, briefs both sides.
Good morning, your honors, and may it please the court. Kai Mann of the Appellate Defender's Office on behalf of the appellant, Justin Steinert, present and ready for argument. May I please request 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor.
Yes, ma'am.
Good morning. May it please the court. Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes the docket for the week of January 30th, 2023.
Hart and Mr. Lang. If you
Thank you, your honors. The case before you today is a summary submission on 2 docketed complaints. What this summary submission is ultimately asking for is that the court impose a 12-month suspension, that this suspension be stayed so long as the respondent complies with the conditions of probation, and that he be placed on probation for a period of 12 months. In looking at Rule 227, which is the rule, our Supreme Court rule, which guides probation in attorney discipline cases, probation is appropriate, particularly in two instances: that misconduct can be corrected by the probation, and that placing the respondent on probation is in the best interests of the legal profession and the public. In this case, Mr. Lang and I come before the court on this summary submission on 2 different docketed complaints. In the first docketed complaint, Mr. Lang and I have agreed to the following facts, rule violations, and the disposition, which was previously discussed. Ultimately, the first complaint arose from a federal lawsuit that was filed in federal district court. An inmate who was held at the correctional facility hired Mr. Lang to represent him in suit against the ultimately, among other people, the Federal Bureau of Prisons, the local correctional facility, the sheriff of that jurisdiction, because he suffered a skin disorder that he did not receive adequate medical care for. He hired the respondent, the complainant hired the respondent in August of 2014. In August of 2015, a year after Mr. Lang was hired by the complainant, he filed suit in federal district court. This lawsuit was dismissed by motion in December of 2015. The respondent waited 10 days after the suit was dismissed to file a motion to amend. The court denied this motion due to the respondent's unexcused delay in waiting till 10 days after the dismissal of the case. Then in February of 2016, the respondent refiles the suit in the federal district court. In this instance, the opposing side files a motion for summary judgment. This summary judgment was ultimately granted as the respondent, while he controverted 3 facts, he didn't provide supporting evidence as required by the federal rule of procedure. In looking at the records of the case, the respondent did not send a copy of the lawsuit to the complainants until April of 2017. When this complaint was investigated, the disciplinary investigator requested that the respondent provide him with billing records. The respondent provided most of the records, but not all of the records. The respondent never provided billing records from May of 2015 to November of 2015 as requested. The final issue in this first docketed complaint was the respondent completed his final legal work in this case in October of 2017. From October of 2017, or I'm sorry, from December of 2017 until March of 2020, the respondent sent bills to the complainant in the case, and they were all listed as interest due on outstanding balance, and the interest due during this period was $10,000. Parties agree that the respondent violated rules 1.1, competence, 1.2, scope of representation, 1.3, diligence, 1.4, communication, 8.4G, misconduct. In the second docketed complaint, the respondent was hired by an executor of a will to represent her in her interests, in that she hired the respondent in January of 2018. In October of 2018, a motion to have the have the complainant removed as the executor was filed in local district court. The court removed the complainant as the executor and appointed an attorney to administer the remainder of the will and the probate to the parties. In June of 2020, the attorney administrator that was hired filed a report with the local district court, noting her procedure, where the assets were sent out to, and some issues that she found in the case. One of those issues that was discovered in this court-appointed administrator's report was that on July 23rd of 2018, the complainant appeared at the respondent's office, asked him to help her find a place to cash a check that was made out to the deceased. They drove around to several banks in attempts to cash this check of $3,268.17. After finding a bank to cash this check, the complainant in this case paid the respondent $700 for outstanding legal services in cash from the proceeds of this check. Beyond just the non-controverted statements from the complainant and the respondent, we know this because the respondent billed for 1.5 hours on this date for trips to the bank with his client, and his billing records indicated that the client paid him $700 on that date. On this complaint, the parties are in agreement that Rule 8.4D was violated as a result of this. Based upon these factors, based upon the aggravating and mitigating factors that exist, the parties are asking ultimately for the suspension that is stayed and probation. The summary submission agreement noted that particular terms of probations would include that the respondent retires from the practice of law by September 30th of 2022, that he work with KLAP to develop and implement a plan for the closure of his practice, that he participate with all ODA required meetings and phone calls, and that he comply with the rules of professional conduct and Supreme Court rules.
Let me ask you about the retirement condition. Because that's stated in the plan, and then we got an affidavit from Mr. Lang a few days ago that paragraph 3 of that affidavit says that he's no longer taking new clients, but he continues to wrap up all client matters. Is it your notion that or intention with the retirement term and the submission forms to what he's actually doing? Retirement can mean different things, and I'm trying to make sure you two are in agreement as to what he's doing.
Certainly, and I appreciate that question. That was something that I've given a lot of thought to this week in preparing for arguments, Justice Biles. I would note the summary submission speaks to requirements of the probation plan and what the parties anticipate will be in the probation plan. The respondent then filed a probation plan on August 3rd of 2022 on the same date that the parties submitted the summary submission. This is a probation plan that Mr. Lang worked with the disciplinary administrator's office on prior to entering into it. And he notes in his probation plan in paragraph 3, subsection D, that the respondent agrees that by September 30th, 2022, or as soon as practicable, if he is unable to wrap his practice of law up by that date, he will not practice law for the remainder of the term of his probation. In visiting with the respondent further after seeing the affidavit that was filed on January 31st or Tuesday of this week, and seeing that paragraph 3 that he continues to wrap up client matters. In visiting with Mr. Lang, he has 5 clients left, I believe. One is a neighbor, one is a family member. He is assisting them in finishing up their divorces. He has closed his brick and mortar office completely. And it is my understanding from our conversation this morning, and he can speak to this more, that he will be done practicing completely by March of this year, which looking technically at the probation rule in our Supreme Court rule at Rule 227, it talks about what the plan is while on probation. And at this point, the respondent is not on probation yet. However, if you look at subsection F of this rule, it speaks to the need to, at least 14 days before oral argument, file an affidavit describing the respondent's compliance with each condition of the probation plan. And probation and attorney discipline cases is unique in that this is a self-directed plan that the respondent comes up with. this is a plan that the respondent shows good faith that he's going to be able to comply and will comply with the probation by showing he's complying with the probation prior to coming before the Supreme Court for oral arguments. And in this case, it does appear that the respondent is not necessarily complying with the terms of probation.
It a stretch of our rule on probation to make a condition of probation retirement. In other words, probation in it, the notion of continued practice. Beyond probation and as a condition, say, I'm not going to practice.
It is a term of probation that you do not see frequently in attorney discipline cases, especially. And again, I began my time up with you this morning quoting back to or citing back to subsection D of 227 when probation is appropriate. And looking at misconduct can be corrected by the probation, and placing the respondent on probation is in the best interest of the legal profession and the public. In this situation, in visiting with Mr. Lang leading up to the summary submission and the probation plan, he had indicated that he is ready to be done practicing, that he took responsibility for what he did in these matters. And by entering into a probation plan that includes an anticipation of retirement and not practicing law, this helps ensure that the respondent's practice is closed down properly, that he is able to move to the next chapter of his life after this. And I think it is a little bit different than if this was something that the disciplinary administrator is specifically asking the court to grant unilaterally that we think that this attorney has practiced long enough and they need to retire. But because this is a summary submission, this is a way to comply with the guidance suggested in subsection D and accomplish those things and allow Mr. Lang as much autonomy and control and dignity in closing out his long career as an attorney in the state of Kansas.
What's your office's recommendation based on what you know now? And as you stand here, what are we supposed to do?
Because this is a summary submission agreement and summary submissions are dealt with by the Supreme Court rule on that, we are bound by recommending what is in the summary submission agreement. This is something that we are aware of. As the court knows, summary submissions are a relatively new tool in the attorney discipline toolbox to use to allow a self-governing profession to allow the respondents to take responsibility and the parties to come to agreements together. But because there is no provision in the rule that speaks to what happens if there's a change in circumstances or that something that is stated in the summary submission agreement does or doesn't occur, it is my position and my office's position that I am bound by the summary submission agreement that's before the court today and am asking for that. I provided the information that I learned from Mr. Lang regarding where he's at with wrapping up his cases pursuant to paragraph 3 of the affidavit So the court will know this and be aware of this new information that has occurred since August 3rd when we entered into this agreement. And I would note that the summary submission agreement notes in paragraph 65, it cites back to that rule 2223F that the agreement is advisory only. The agreement will not prevent the court from making its own conclusions regarding rule violations or imposing discipline greater or less than the party's recommendation.
A little confused about the respondent's probation plan. That, do I understand, you said that you had worked with him on it. Is that the plan that you think is in place and is that you're asking us to put in place and is acceptable? And part of my reason for that is I found when I was reviewing as a preparation for argument that paragraph 3 was confusing to me. It felt like there were provisions in there that were hard to reconcile because it does talk about closing the office by September 30th, but then says that, of course, that would be with the caveat of ensuring clients' interests are not negatively affected. And then subparagraph under that, little II, says that if respondents unable to close by September 30th, that the respondent agrees to the following and sets out that there will be lists provided to KLAP and ODA, et cetera. I'm not sure if that has happened from what you have said. But then later, under D, as you quoted, it goes back to agrees to be that if he can't wrap up, he will not practice law. So that little 2 and D seem conflicting to me. And so I was not real sure what the party's intent was here or what you were asking the court to do in terms of probation terms. But it also makes me believe that there is some leeway here with the respondent wrapping up his practice still as of today. So can you help me understand what the intent was and what you're asking us to do with by those provisions?
Certainly, and entering into this probation plan, when it was proposed and developed by Mr. Lang and signed on August 3rd of 2022, it was Mr. Lang's, I believe, and he can certainly speak to this if I get any of this wrong, Chief Justice, but I believe it was his desire and belief based on his assessment of his cases that he would be wrapped up by September 30th of 2022 with his practice and be done. But there may be a chance that there would be a few cases that would not be wrapped up by that point, and that he would work to diligently wrap those up as quickly as possible and keep the parties apprised. I would note that Mr. Lang did not provide monthly updates as set forth in subparagraph 2 of 3I. And I believe the justice asked that earlier. In visiting with Mr. Lang today, he did note that it is his belief today that he should be done with all of his cases by March, which depending on the court's reading of our rules that guide us, he will be at a place when he is actually on probation, should the court choose to grant him probation, that he will not be practicing law any longer. So I would agree with you that there is a little bit of wiggle room on here. There is not 100% compliance with even the wiggle room that was set forth in the proposed probation plan. And I can't speak as to why or why not that would be.
Clarify, if we would order a probation, it would be pursuant to this plan? or are there additional, just the bare bones, what's in the summary submission?
It would be in the respondent's probation plan that was submitted when we were preparing to enter into the summary submission agreement, because as Justice Stiegel noted, this is a rather novel way of wrapping up one's career and resolving a disciplinary complaint. I wanted to make sure there was language in there for not only the president of the Board of Discipline that would be reviewing the summary submission plan, but whomever might pick up the summary submission and read it and see that we're putting him on probation, but it is a out of the ordinary probation. And as you can see by the rule, there's no requirement that a probation plan be submitted when a summary submission is entered into. The language I'll speaks to before a formal hearing. And when you enter into a summary submission, a formal hearing doesn't happen. So there was a little bit of ambiguity based on our rules when the summary submission plan would be completed by Mr. Lang and submitted. And the proposed plan did end up being submitted the same day as the summary submission agreement was. But that wasn't necessarily an intentional working of all the parties together. That's the dates of where and how it happened.
Can I ask a question? You started off by saying that the ABA talks about probation and that misconduct can be corrected by the probation, and it would be in the best interest of the public. And it seems like that everybody agrees on the misconduct and how to correct it. Normally what happens is you have during probation a supervisor that kind of monitors, what's going on with cases. And so the misconduct can be corrected by probation because there's a supervisor meeting once a week, et cetera. And that's in the best interest of the public, to protect the public. But here it seems like that the misconduct can be corrected by the respondent retiring. And what concerns me is, if he had stopped practicing on September 30th, 2022, maybe that would be the case, but he's still practicing, and really he doesn't have control over a docket or when a judge is going to say, you know what, we're going to continue this divorce case. So it may not be March and it may not be next September. And meanwhile, we have no monitoring, and it actually could exceed the probation period. So can you speak to, I guess, the fact that the correction that you're talking about is him retiring? We can correct the misconduct by him retiring. And then, of course, he's not fully retired. He's not done practicing.
Absolutely, Justice Steinert. And that goes back to the conundrum that the position that the disciplinary administrator's office has been placed in now is when.
Well, I guess my question is, you've asked for a 12-month suspension, and then that suspension be stayed pending probation. Why shouldn't we just go ahead and do the 12 months suspension?
And that is certainly well within the court's purview to do that.
Doesn't seem like the misconduct being corrected by the probation plan that's been submitted. And it certainly doesn't seem like it's in the best interest of the public.
I would note, going back to your where you started with your question, Justice, is looking back to that paragraph, that subparagraph 2 in paragraph 3A, if the practice is not closed down by September 30th, 2022, respondent agrees to the following: provide KLAP and the disciplinary administrator with monthly updates due on the first day of the month, how many clients he has left, the names of these clients, and an update of the soonest possible date he plans to complete the case or hand the client's files off to another attorney.
And that's targeting the retirement. That's not targeting the misconduct. The misconduct was some bad decisions were made here.
Correct.
And what's to prevent some bad decisions from being made? Even though I've let you know how many clients I have, I've given you an update on when I think the file is going to close, et cetera.
And I would agree with you based on the performance of the respondent leading up to this. I share those concerns to a certain extent because the probation plan anticipated that he would be done by now.
Basically be the same thing as a suspension.
Correct. And I would note, looking at our preamble, it talks about how the legal profession especially is a self-governing profession and the importance that we need to govern ourselves and show this respect for the rules, the law in our own actions and the importance of that. And I do share your concern that this hasn't been met for the respondent. I would note, if you look at the summary submission, this respondent, when you're looking at the aggravating and mitigating factors, I would note that while this respondent has had 3 prior informal admonitions, he has never appeared before the court before on any sort of disciplinary matters. He has been practicing since 1983. I would note that he made a good faith effort for restitution in paying and writing off the outstanding balance of interest charged in the first complaint. And I would also note, and the respondent may speak to this today, in June of 2021, he suffered a stroke that resulted in health complications. And it's my understanding that in October, I believe, of 2022, the respondent had a heart procedure and stents placed in his heart that all signs seem to be pointing to he needs to slow down. He needs to stop practicing law. And by stopping practicing law, that protects the public. It allows Mr. Lang to retire from the profession that he has been in for almost 40 years. And it also allows him to take responsibility in knowing that if he doesn't comply at this point with whatever terms of probation the court ultimately imposes upon him, once he is actually on probation, the disciplinary administrator's office has procedures in place and has consequences in place for not following the terms of probation. So as far as making sure the public is protected, it is either protected by the filing of a probation violation, should he not comply with the terms of probation, or filing a new disciplinary case, should he violate our rules of professional conduct.
Questions?
Thank you.
First of all, I'd like to say I'm very embarrassed by this situation. Very sorry. very humbling to me, and that I so sorry. Can't understand how embarrassing this is for me. Now, this has been a long process. And on several occasions, I had conversations over the phone with Ms. Hart and told her exactly what was going on. That I had a couple of things that I was wrapping up, trying to wrap up sooner as opposed to later. And if any time she'd have told me, no, you can't do that, I would have dropped it. The only reason I kept these people had very little left to do. I knew if I dropped them, they have to go find an attorney, pay a retainer, all of this and all of that. And but once again, if she'd have told me, no, you can't handle these things, and I'll do that tomorrow. I just have no problem with that. I'll be glad to do that. I was just afraid I was gonna make a situation worse for my clients, and none of these things that I still have going on are of much substance at all. They're just simple divorces that just need to get resolved. Now, I've got one neighbor boy. I told him when he first asked me to handle this, I told him I'm retiring and I'll get you as far as I can. That's where I am with him, and sure he'd understand if I told him that, this is it, and I'll help you find an attorney or you find one on your own. But based on the language in that agreement, I felt that we could continue these things. I assure you, I didn't take any new things or wouldn't have continued if it had been very complicated at all.
Well, given that you continued, did you file them? I understood from Art that didn't file your monthly updates that you agreed. Effective, are you missing filing of any monthly?
I don't think so, Your Honor. First of all, the probation agreement had never been approved by this court. So I didn't think that it was a final document. And also, when I talked to Ms. Hart, there was never any, you need to do this or you need to do that. And if there was, I would have done it. Now, Ms. Hart correctly stated I had a stroke. I've had COVID twice. I've lost my long-term secretary. I've been struggling. And then in October, I had a heart attack and quadruple bypass surgery. It hadn't been fun the last year or so.
I want to be clear, that was October of 2022.
Yes, sir. So, I still am recovering from that and have chest pain every day. I'm limited in what I can do. I don't want to practice law anymore. Really don't.
Mr. Lang, is it important to you, the way that the summary submission was 12-month suspension would be stayed, and probation would be implemented. Is that important to you that it be probation instead of a suspension? Because you mentioned that you would drop all clients tomorrow and quit practicing law. So if we made an order that your law license was suspended, that would mean that you would drop all your clients tomorrow. Does it make a difference to you about whether we would impose a suspension versus a probation?
Honestly, it would make me happier if it was probation.
Because it kind of seems like that's what's going on here, because the probation terms are, I won't practice, which is really the practical effect of a suspension, but it's just under the probation heading. So I wondered if that was, that was just really important to you.
I'd rather, be quite honest with you, have it called a probation than.
Thank you for your honesty.
Make any sense, probably not, but you know, I've done this for a long time. And oh, I've done a lot of good for a lot of people. I mean, I just can't overemphasize how sorry I am. My whole life's been turned upside down in the last 2 years. I'm lucky to be alive here. And practice, I want to get all this stuff resolved. I don't want to come waste your time. I just want to move on with my life and get everything in boxes and get it resolved, and that's my goal. I don't want to cause anybody any problems. Like I said, you tell me I gotta stop doing this tomorrow, I'll tell my sister, I'll tell my neighbor, I'll tell the 2 or 3 other people, and that's fine, you know. It won't be the end of the world for them, you know, but I'll help them all I can.
How many clients do you have left now? And
I
just
think
an estimate of how much longer?
I've got
representation would-
one in Missouri. And I'm not really even sure what that does, but he won't respond to me. I've been trying to tell him for a month or so that, hey, I'm not gonna be your lawyer. We've got a trial set in March or early April, or maybe even be February. But finally, after he wouldn't respond to me, I filed a motion to withdraw like 3 weeks ago. Still haven't heard from him. So that's one. My sister and I I've got everything done and filed except the decree. And if you want me to, I can drop her and she can go in and do it herself, you know.
On a general estimate of how many clients and how much is left?
I think I've got 4 Kansas clients left and then that one Missouri. I've got court dates. Got a court date for one of them. That's, I think, in March. That should resolve everything. It should. Like I said, it may not, but and then my sister and the neighbor. The neighbor's deal. The other attorneys. Not real easy to get things settled with, so. That may not get settled, but we do have a status conference in that in the next couple of weeks. I could at least tell the judge, you know, here's what we're doing. I'm gonna retire. You know, find him a new attorney. I want to quit my practice. I could have done better. I mean, I could have told people I'm done, but it just seemed like it was gonna be such a hassle for them, and the language in that agreement said unless justice requires, and I've told Ms. Hart on several occasions, I'm still doing this, this, and this. And it never seemed to be a problem until today. Anyone else have any questions I could answer for you? Thank you so much.
Art, you reserve 3 minutes.
May it please the court. I would note in response to Mr. Lang's comments today that when you look at Rule 227, which is the probation rule, it notes under that subsection F that we spoke about earlier, the following provisions apply to a respondent who seeks to be placed on probation. When the times that Mr. Lang and I did speak on the telephone, the disciplinary administrator's office or myself is not in a position to order him to do or not do something at that point. It is his duty to know and to do what he is supposed to do. He was notified several times throughout the complaint of 227 specifically, of the rules of 227. And I believe that
So are you saying that, once a probation plan is submitted, does compliance begin immediately? Or is that something that is kind of ambiguous? This is the probation plan if the court decides to impose probation. And so at that point, I'll comply with the probation plan. Or is it something that, okay, now that I've developed a probation plan to show good faith, I'll start complying immediately?
and that's where probation, when you are an attorney on a disciplinary case, is a little bit different than in a criminal probation where the conditions of probation are imposed by the court and then are being followed. In short, to answer your question, it appears that the way the rule is written, it falls on the respondent to come up with the probation plan, to follow the probation plan, and
Follow the
to
probation plan when?
the date that keeps getting referred to in the rule is that 14 days. And you see that in that subsection F, that at least 14 days before the oral argument before the Supreme Court, the respondent must complete the following: file with the Supreme Court and the disciplinary administrator a copy of the affidavit describing the respondent's compliance with each condition of their probation and any relevant reports. Now, I do want to refer back to the preamble again, because I think that this preamble guides why our probation rule is what it is and why the responsibility falls largely on the respondent in developing and self-implementing a probation plan. If you look at section 10 of Rule 240, which is our preamble on page 321 of our rule book, it notes the legal profession is largely self-governing, although other professions have also been granted powers of self-government. The legal profession is unique in this respect because of the close relationship between the profession and the processes of government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested largely in the courts. And then you look at It's section 11 or comment 11 next that says, to the extent that lawyers meet the obligations of their professional calling, the occasion for government regulation is obviated. Self-regulation also helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on a government for the right to practice. And then 12 sums it up with the legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to assure each of its regulations are conceived in public interest. And it goes on and talks about that, but I would be so bold as to surmise that part of the reason why our probation rule for attorney discipline cases is written the way it is because we are a self-governing profession that has the utmost respect for the rule of law. And that's why the onus is placed so much more on the respondent to develop a probation plan and to have that probation plan carried out before the respondent appears before the court and asks the court to grant the probation plan. And I want to touch base on another question that you had asked, Justice Steinert. The disciplinary administrator's office has no teeth if a respondent submits a probation plan and we are pre-Supreme Court oral argument that if the plan isn't being followed, I cannot file a motion to revoke his probation. I cannot unilaterally issue sanctions.
I think
that sort
Mr.
of
Lang is saying that he didn't know that the probation was effective right away. He thought he was submitting a probation plan and that it would go into effect when the court ordered it. So I think we have a basic misunderstanding or cross communication about, was it in effect? And that was my question, but I'm good. Thank you.
Thank you very much.
Thank you to both of you for your arguments today. The court will take this matter under advisement. We'll now call 122-418, State of Kansas versus Justin Steinert.
May it please the court. Justin Steinert was sentenced with a criminal history H due in part to inclusion of an Arkansas conviction. But the prosecution failed to carry its burden to prove that Mr. Steinert was properly sentenced, as the PSI and the journal entry of the Arkansas conviction failed to provide information from which Mr. Steinert's criminal history score can be accurately determined. The question is, what can be done about this on appeal? And today we have three broad avenues of inquiry, all leading to a positive result for Mr. Steinert. First is 6814D. Second is the motion to correct an illegal sentence filed in the appellate court. And third is revisiting State v. Corby. However, I do think that 6814D offers the clearest and best path to deal with this problem. And that's where I would like to begin now. And as we begin with any statutory interpretation issue, begin with the plain language. And when we look at 6814D, those 5 sections have an awful lot going on. And I'm going to start, again, super remedial, but going to go through each one individually, particularly the first sentence. If an offender raises a challenge to the offender's criminal history for the first time on appeal, the offender shall have the burden to designating a record that shows prejudicial error. Now, the first problem we have to come up here, the first issue is, what is prejudicial error? Now, Mr. Steinert, as we've argued before and all the thousands of papers I filed in both courts dealing with this issue. Mr. Steinert, when we look at the PSI, we can't tell what crime he was convicted of. The statute listed in the PSI is not a crime. Now, it is within a criminal code, but it does not define the elements of crime. Furthermore, so therefore, when we look at this, and Mr. Steinert is an H, that means if he has 2 misdemeanors, 1 misdemeanor goes away, he is an I. There is not enough information in this record to show that the state accurately scored this thing. And so therefore, he is plausibly right now an H and an I. This is an
Can I ask
ambiguous
you a
sentence.
preliminary question?
Mhm.
You're doing the statutory analysis, but for this statute to apply, we don't need to retroactively apply the statute. Is that your understanding?
My understanding of the statute is when I looked at this, again, I've been looking at this a lot. I do believe that this statute applies to every case from the date of its inception, and it must be applied retroactively because it is a procedural statute, because it controls the procedure for handling illegal sentence claims for the first time on appeal. But more importantly, it's a remedial statute.
Well, it became effective
July
during-
1st.
and your appeal was pending at
Mhm.
the time it became effective, right?
Correct.
Okay.
And this is also a direct appeal. This is not a collateral attack. I just want to make that sure because generally changes in the law benefit appellants who are on direct appeal. So we are on direct appeal, not a collateral attack. So therefore,
I think what Justice Wall is saying is
Yeah.
that it doesn't really have to be, we don't have to make a determination about retroactivity because he's on direct appeal, and so it
yes,
applies.
yes, yes,
I could
correct.
be wrong,
correct.
Justice Wall,
Yeah.
but
Well,
Thanks
no.
for stating it more clearly.
Well, either way, I agree with both of you. So we'll go there. But so we've come up with this issue of prejudicial error. Now, when we look to the definition of an illegal sentence, an ambiguous sentence is an illegal sentence. And because this inclusion of this Arkansas conviction directly controls Mr. Steinert's sentence, he's serving 71 months right now. As an I, the highest number in the I3 box is 61 months.
let me ask a question. And I realize you're going to the substance and the merits, but isn't really the question here or your claim of error is that, I guess, because the statute applies, that the appellate court should have considered the journal entry. So the order entered by the Court of Appeals, it said we're not going to consider the journal entry. That's what you're appealing. So couldn't we, I mean, isn't the issue introducing it? Or do you want us to go to the merits? Because isn't the first hurdle is, do you get to introduce it? Or is that a moot point because the Court of Appeals wasn't dealing with the amended statute?
So I sensed a couple of parts there. So I'm gonna, no, you're fine. I'm just gonna try to answer them all here.
Okay.
First off, as proposed remedy, I do want this court to reach the merits, and I would like this court to remand this back to the district court, the criminal history I, because the PSI, the journal entry, we've shown that there's no way the state could have done this correctly.
Or to impose a criminal history of
I,
or to determine whether or not, based on the evidence, prejudicial error exists, because isn't that a fact-finding function?
well, see, in my opinion, prejudicial error existed before I added the journal entry. Because when we look at the PSI, we cannot tell what Mr. Steinert's criminal history is, and therefore we can't tell if his sentence is correct. This is an ambiguous sentence. It could be at 71 months at the most. It could be 61 months. at the
Didn't it
most.
include the Arkansas conviction that you supplied what you call a journal entry for?
Yes, well, just like point out that Arkansas also called it
What's
journal entry.
and your point is, based upon what you have submitted, is that there's no evidence that it was a counseled conviction. Is that right?
That's half of it, that there's no evidence there's counseled conviction, and that journal entry does not disclose a crime of conviction where I can go identify elements. How this arose is when I was working on this, I had a PSI and I saw an out-of-state conviction. Now, whenever I have a PSI with an out-of-state conviction, the first thing I do is I go look at the out-of-state statute so I can do the comparability. Again, I'm a veteran of the comparability wars. I know how to do this. The problem with this case is that after I looked at the PSI, there was no elements. So I called down the district court. And when I called the district court, my thought was not to add this journal to the record. I was just trying to find a set of elements to compare with, right? And if I couldn't, then I probably wouldn't raise the claim because what's the point in that? But then when I found that the journal entry itself didn't have a crime, now I know there is no way Sedgwick County did this. That is prejudicial error. Our grid system requires prior convictions to be properly scored. But that didn't happen in this case, and it is their burden pursuant to 6811E5.
Is
Now,
that
but
is
then-
that the intent of subsection D though?
What?
I mean, is that is that the intent of D? That that would be, to me, you're setting up a binary choice of the appellate court finds error and corrects it, or determines it can't find error and therefore it's prejudicial error.
No, because under subsection D, if you're not sure if there's prejudicial error, you can remand it back to the district court to find prejudicial error.
But I think to me, and maybe I'm missing something, your argument takes out any fact finding of that, because you're saying if they didn't prove it, it's prejudicial. If they didn't have it at the time of sentencing, it's prima facie prejudicial error.
Well,
So why do we need to, what is the purpose of any remand?
Because,
For the district court to say the same, that?
because from what I understand is that this court can't say criminal history, I resentence you at 61 months. The district court would have to resentence under this correct criminal history. But I think under here, that I've shown that there's prejudicial error, the state had, and again, 68D allows the state to show a lack of prejudicial error. So I guess, why hasn't the state also come up with their journal entries and also blocking a remand?
But let me get your argument right. So you're saying even if you had not run across the journal entry, okay, the PSI had a statute in it that doesn't have elements.
Correct.
So it's an illegal well, I guess.
Well, say, and on top of that, the crime as defined was theft / shoplifting. Arkansas has an entire Article 5, subchapter 36 of the entire Arkansas Criminal Code is theft. They have like 6 different crimes labeled theft, not one is shoplifting.
Okay, so your first argument is even if I had never had the journal entry, kind of shows that it might be uncounseled. I would have appealed this anyway because it's a non-element offense.
Well, and frankly, when I did appeal this, I raised this under Obregon because remember, I filed this brief in 2020. Corby was still 2 years away. And so I was under, the only reason I tried to add the journal entry is because I will be quite honest, after dealing with what I've dealt with Sedgwick County and dealing with other cases in Sedgwick County, I try to leave as little wiggle room as possible with remand. And if I could show that there is no possible way this court or that Sedgwick County could call this an H, then my client could be an I. I've had a client where I've won multiple appeals and he served his whole sentence because Sedgwick County messes things up on remand. So here's the problem with this is that these things take so long. We have people over serving. And frankly, if the state would just prove these at the beginning, 6813 requires, if you look in the PSI, the category of information, this was Cleburne County District Court records. 6813 requires journal entries and documents that they get to be attached, not in this case. So really, when this is kind of,
Is there a way to? You've supplied us or attached a document that indicates that there's a crime and a plea to a theft / shoplifting. Is that now to be ignored because it wasn't included in the original PSI?
no, because that theft / shoplifting shows that it still can't be scored. I guess what I'm saying is that the journal
Why
entry,
why can't it be scored? Because there's,
because you have to fact find, because without knowing the elements, because under 6811 EB2, I believe that's it. For an out-of-state misdemeanor to be scored, it has to be comparable to a Kansas class A or B misdemeanor. But if we can't find the elements of the out-of-state conviction, then we have an Apprendi problem because we're just assuming and we're just fact finding that they are comparable.
the Arkansas statute has no elements.
I'm just saying that I don't know which particular crime he was convicted of because they haven't supplied that information. Now, if you want me to do a comparability analysis for the entire Arkansas theft subsection, I think that's a little bit outrageous when they bear the burden to prove these. And this was obvious.
But
Well,
no, go ahead, Chief.
but we also have a statute that sets up who has some responsibilities at sentencing.
True.
And
Mhm.
as I understand it, this defendant agreed to this criminal history.
True, but I also think that that is brand new from Corby, and I think I think Corby misses the difference between criminal history and criminal history score. I was up here in September talking about this. You can admit to criminal history. I can admit to the fact of a conviction, but how that score is determined is a legal question. I cannot stipulate to a legal question as this court has said in Stoll or the legal consequence of stipulating facts. So all the
That's
defendant.
why you argue for an overturn of Corby, but it's to address the question I think Chief just asked, that without that remedy, you're the defendant at sentencing didn't trigger or test the burden of proof. Therefore, that shifted now that we're into the appellate
Right,
phase.
which means I can come and prove it later. And again, as I said earlier at a different argument, criminal history and criminal history score. Now, this Roberts issue where I'm saying this is uncounseled, that's a criminal history problem, because I'm saying this conviction cannot be included in the pot of all convictions that are then classified to get to a score because it was uncounseled. Now, if I can't find the elements, I'm not disputing the conviction exists. Mr. Steinert was clearly convicted of something in Arkansas. I'm just saying I can't tell. And if I can't tell, they can't tell. And if they can't tell, then we're just throwing darts at a dartboard to pick a criminal history. And that's not the way this works.
Can I ask you one other question? I'm sorry, were you done?
No,
addressing that?
I think so.
So you've argued for two different paths for remand, one through the illegal sentence statute, one through the recently amended 6814. I don't see that we can do both, but is 6814 the more specific statute here that would
Well-
control your remedy, or?
I think it's actually interesting because really, when you look at these both closely, it's kind of the same procedure. Because I'm just talking, I see I'm out of time. I don't know. Can I? Okay. Because we go to the legal sentence statute 223504. We're to look at that one, plain language. The court may correct an illegal sentence at any time while the defendant is serving such sentence. Again, I noted in Keel, this court correcting a legal sentence on a motion filed after the petition for review had been granted. So the Court of Appeals was just clearly wrong about saying you can't file one in the court. And even more so, at that time when I filed that motion, the district court had no jurisdiction. So if the only way, if you can correct an illegal sentence on any time, then I necessarily have to file in a court that has jurisdiction, or else you can't correct in the sentence at any time. So the appellate court, as the Court of Appeals with the only court with jurisdiction, was necessarily the only court I could file that motion in. And I provided it for this. And the second, we go to the definition of hearing, but most importantly, if the motion, files, and records of the case conclusively show that the defendant is entitled to no relief, you have a right to a hearing. That pretty much mirrors the language of 6814D, the last section, or E, or the last sentence of that subsection, where the court may remand the case if there is a reasonable question as to whether prejudicial error exists. So all I have to do is show a question under both statutes. And I've clearly done that. So at worst, this case is going back to Sedgwick County. The only difference is whether or not it's going back with instructions to resentence out of criminal history I or not. And I have no more prepared remarks on this. If any more questions, I'd be free.
Is what you provided a journal entry?
Arkansas declares their journal entry.
I'm sorry, Arkansas what?
Arkansas says the journal entry. I'm
Okay.
yeah. The affidavit I supplied that I called down there. I've called down Cleveland County so many times, and I was very mad when I got that response because I don't like being called a liar. I probably shouldn't have said that, but I'm just going to sit down now. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I want to start and state from the outset that the state is completely unclear how or why we are still here doing this as opposed to trying to resolve this in the district court. We've gone so far.
How does he get to district court?
He can file a motion to correct a legal sentence in the district court.
How, why, when the case is on appeal?
There are I would have two responses to that. Number one would be that under some of this court's prior case law indicates that that the district court could have concurrent jurisdiction over issues as long as it doesn't really impact or affect things that are issues currently pending on appeal. I'd cite Dedmond at 230 Can 793. And Thurber at 313 Can 1002. Just for the principle that when there's not a conflict, there's nothing that would stop the district court from doing this. And I think a little bit of the problem here is that my second response is, if we're going to try to somehow suck 6814 into this appeal, it doesn't make sense to me that the defendant continues to ignore the remainder of that bill. And that was 216820 little I, that expressly grants the district court concurrent jurisdiction to evaluate a motion to correct an illegal sentence, even while a direct appeal is pending. It makes no sense to the state why we are here today.
Current means concurrent. I mean, so what is, they apparently felt it was okay to do something in the appellate court. And we take our jurisdiction from the statute and they've given us concurrent jurisdiction.
And then the issue that we run into here is what this claim is. And this is a fact-based claim. Unfortunately, this court is not a fact-finding court. And so I want to start with,
That why D comes? It's
no,
fact finding?
no, candidly, no. And I will address 6814 D. But I think that we have to start first at these claims of ambiguity. The claim that the state somehow failed to carry some sort of burden. Corby, Roberts, the plain language of the previous version of 216814 subsections A through C that have been in effect since 2010 made it very clear that the defendant's admission in this case satisfied the state's, satisfied any burden that there was. He admitted that his criminal history, and uniquely in this case, his criminal history and his criminal history score were correct. So to say that the state somehow failed to carry a burden there's no basis in law for such a claim. That his admission carried the day. And so,
But why doesn't the submitted journal entry carry the burden after it shifts to the defendant under subsection D?
subsection D, to be perfectly candid, the state has a number of issues with subsection D. And we have a number of issues with the submission that has been provided. The state is not of the opinion that that is a journal entry. And to be clear to my colleague, Mr. Mann, no one's calling him a liar. We just don't, that document doesn't say that it is a journal entry. That document contains, at best, acknowledged ambiguities in it that may or may not be consistent with reality. So there's a lot more here. So
Did you undertake to we know you didn't submit additional documents.
correct.
Or an attempt to locate additional documents or?
And we're talking about a lot of things that are completely outside the record here. And so if your honors will allow me, I will do so. But if I get too
I'm
far
just
afield,
wondering if that was the more fair way for me to phrase the question was that a conscious decision on the part of the state?
I guess I would have two responses to that. Number one, we do not believe that this is a journal entry, so we don't feel that any burden or duty has shifted to us to try to respond. And number two, I can tell you that we have not communicated directly with the court in Cleburne County, Arkansas. We have spoken with the prosecutor and have attempted to try to initiate some processes here, but there is conflict in language that's used and the processes that are employed there. But I think that proves the point.
It sounds like from everything you've said that if we concluded that there was a reasonable question remaining about prejudicial error, I mean, you started out saying, why aren't we in district court? So you would be okay with not objecting to this case being sent to district court for a resolution of these issues.
I think that that's correct. That is legitimately the absolute worst position that the state could find itself in here. The problem that the state has is, how do we get there? What we have is a document appended to motions. And I mean, I can tell this court that Mr. Mann has tried repeatedly to add this document to the record on appeal. He tried in the district court, but failed to set a hearing to actually litigate this matter. Then that request was denied. his request has been subsequently denied 4 times as outlined by the Court of Appeal.
Why don't we get
Why-
through?
Oh, go ahead. Well, I'm just gonna ask, why are you fighting this? Don't you want some semblance of truth in what is here? I mean, the state has as much interest in getting an accurate criminal history as the defendant.
Absolutely.
Duration of sentence is dependent on it, and I don't understand why you're fighting it, or fighting it so to the point where you're trying to exclude what is perhaps the truth. I just don't understand it.
We want to get to the truth. What we're fighting about is how do we do it? And that's my whole point. This court is not a fact-finding court. I cannot drag a defense attorney in here from Arkansas to testify, hey, I actually did represent this person, even though the
Well,
defense attorney.
what is, let me go to that. 216814D allow? Doesn't it allow that? Doesn't allow necessarily fact finding, but it certainly allows evidence to be introduced at the appellate level, doesn't it?
It provides for certain types of evidence to be introduced, I would say. And so let's talk about that plain language. The offender shall have the burden of designating a record that shows prejudicial error. And that was one of the first questions that came up, is what is prejudicial error? I'm not exactly clear on what that is or isn't, because, but what I am clear is that the statute continues to say that if the defendant can't do that, then this court shall dismiss the claim. So then there's tension with the last provision in that statute that offers the opportunity for a remand. So I don't think that 6814 is clear. I don't know that it's even workable. Again, we're slightly outside the record here. Our office would
Well,
have, go ahead.
I'm sorry, I didn't mean to cut you short there, but your explanation of subsection D strikes me as identifying 2 different standards. One, if prejudicial error is actually established. And then later, the last sentence in subsection D, if it maybe isn't conclusively established, but reasonable questions, then there's a standard that permits remand.
Correct.
Is that your reading of the statute as well, or the newly amended subsection D?
I'm afraid those 2 are in tension, because I don't know exactly what prejudicial error is or what or how a defendant can demonstrate that. I can explain the legislative history here, though, and it's fairly clear on the face of the statute, but if you read the testimonies that were submitted, the entire goal of this new statutory amendment in addition was to do 2 things: to resolve the easy cases where Kansas courts can take judicial notice of Kansas documents and records, and therefore cut down on the number of remands. But even more importantly, and part of why 6820(i) was included here, is to force these matters back to district courts where we can conduct the appropriate fact finding.
For those cases that aren't so easy.
That aren't so easy.
With-
Yeah, and I think that's clear on the face here in that it tells this court, to the extent that you're fact finders, it only offers you the opportunity to take judicial notice of documents from Kansas courts which this court would oversee. It makes no such provision for out-of-state documents.
Okay, so on an out-of-state document, a couple things in subsection D, it isn't limited to journal entries, right? It says the offender shall have if the offender shall have the burden of designating a record that shows prejudicial error. So the first question is, even if it's not a journal entry, is that enough? So that's my first question. Why does it have to be a journal entry?
I mean, it doesn't, but the question that jumps over the question of designating a record. And the question I would have is, how do we do that?
Well, he did it, designating a record by appending it to an appellate court. If an offender raises a challenge for the first time on appeal, I mean, there is something in there about an attachment. In designating, a defender may provide the appellate courts with journal entries. That's an example.
Yeah, but I think, as my opposing counsel would acknowledge, the process for how that's done is completely unclear.
Why is it so? It just says provide the appellate court. Why is that difficult?
Because because of our court rules, rules 3.0, 3.01, 3.02, 6.02, and 6.03 all make it clear that what is the record before this court has to have been something that was done in the district court. Has to have been part of the whole record, below, so that this court can then review it. Again, we have no mechanism through which I can factually try to vet the document that the defense has tried to append. I would also note that his motion and his brief, that while he's appending it, there's no rule that provides for him to be able to just append a matter of fact, a question, and present it to this court. No rule provides for that.
But in the easy cases, isn't that supposed to be the easy cases?
The easy cases would be those, and there are sometimes that parties could come together, perhaps, if we're asked.
So
And
only if the parties come together?
that would be probably the only way that you could resolve a complicated out-of-state question.
But what about the language that says that the
Aside
state-
from a motion to correct an illegal sentence filed in district court, I apologize. That's the most efficient, the fastest, the clearest, the appropriate way that we can designate a record too.
But it also says in here that the state then may provide the appellate court with journal entries establishing a lack of prejudicial error.
Correct.
But there's the vetting, right?
I don't know. That's the problem
Well,
we have here. Is
If you had a plea agreement in this Arkansas conviction that set forth, that was just a slam dunk, you win because you have a plea agreement. It's sitting over there at council table. You would have filed it with this court. Are you really saying you wouldn't have because you can't identify a rule that lets you do that?
But I would return to my initial answer. I don't know that what the defendant has provided in this case triggers any duty upon the state.
I know, I'm just.
I
saying-
would not misrepresent anything to this court if
Of course,
I'm.
I'm not suggesting anyone would. I'm just saying you're making a procedural argument that these things can't come to us. And I'm just asking you to imagine if the search situation was reversed. If you had a document that on its face, slam dunk, state wins. It's a complaint, a plea agreement, or a jury instruction verdict form. Those are the things listed in the statute.
Right.
And your opposing counsel, defense counsel says, wait, they can't do that. They can't submit that. I mean, it just seems to me that the arguments would be completely reversed. And it's back to Justice Rosen's question, why are we having this argument?
I think the arguments would be completely reversed, and were they reversed, I would say that Mr. Mann should win. I think we're having the problem here is that the correct
You
mechanism.
don't, in other words, you're admitting if you have back there at council table an Arkansas plea agreement that shows the state wins, you really don't think we can consider
I don't know.
reading of the statute.
I don't know how I would do it, is all I'm saying. I don't know. Because it's not clear. And that's the best that I could offer. I could tell you if I had something that said that the state definitively would lose, you would probably see us running to the district court. Brought to our attention.
Let me give you a hypothetical. Let's say that in the PSI, it lists a prior conviction. Was this listed as a felony or a?
No, it's a misdemeanor.
Misdemeanor. Okay, so it's listed as a misdemeanor. And it gives a statute number. And it gives the name of it, and it's it's burglary, whatever it is, shoplifting. But then you go to the statute that's listed there, and it's actually a statute on auction of livestock,
Right.
right? Okay, so what would happen then?
I think we would have a motion, we'd have to have a hearing and litigate a motion to correct an illegal sentence.
Okay, and so
At the
then your
district court.
issue on that one is, since that's exactly what happened here,
I wouldn't agree with you on
well,
that.
there's no elements in this. It says, the name of it is consolidation of offenses, theft by deception, presumption at an auction of a livestock.
That skips over and ignores that the state had no burden thanks to defendant's admission. His admission was to the crime, and I admit, it lists a statutory evidentiary presumption, but also names the crime as theft. shoplifting. And as I set forth in my original brief, theft is very clear in Arkansas statute, and it is identical to Kansas's theft.
But that statute isn't. If your goal here is, as Justice Rosen said, is to get to the truth, why? I mean, clearly they referenced the wrong statute, right? No elements in the
There
statute.
are no elements in that statute. It's irrelevant. It's only relevant as a presumption, I believe, in the context of shoplifting.
So what statute are you to use? Because there are a lot of statutes with the word shoplifting in it.
No, but there's only one Arkansas theft, and as I set out in my original brief, it's this exact same chapter. It's subsection 5-36-103. And we did not have any additional burden here. All burdens were satisfied thanks to the defendant's admissions here.
Right, but that's, okay, so, and your issue on that is, if we were just to decide it on that is, you can't hear a 3504 motion that was raised for the first time on appeal.
I don't think that this court can evaluate an illegal sentence motion for the first time on appeal when it turns on a question of
It
fact.
doesn't, but it doesn't turn on a question of fact, because 6811E2B says if a crime is a misdemeanor in the convicting jurisdiction, you're only supposed to compare the elements.
Right.
But there's no fact finding.
Are you suggesting there may be another journal entry?
I'm suggesting there is more. I'm suggesting there's a prosecutor that's named, there's a judge that is named. I am suggesting that there is more that can be done here.
But if there's more to be done, doesn't the 6814D put the impetus on you to provide the appellate court with journal entries establishing a lack of prejudicial error?
Not when what the defendant has done has not officially been added to the record. Not when what the defendant has provided does not meet the definition of a journal entry. I would also note there's absolutely no indication or claim that what he has provided is something that can be provided because it wasn't originally attached to the criminal history worksheet. There's been no claim to that end. So I'm suggesting that there are other things that can be done if he's going to litigate this claim. And I would also return to the reality is that when he made these original claims before the Court of Appeals, the defendant did not assert that his sentence was illegal. He asserted that it might be. That should have been the warning sign, as the Court of Appeals found correctly here, to just draw the line in the sand. What we're talking about are questions of fact. Appeal was a different matter. That was an issue of law. This court can determine issues of law. But what we have here is a question of fact.
I don't
Question of
understand.
purely a question of law versus purely a question of
What's the
fact.
difference between Keel and this?
And this Keel was a question of law.
But explain that to me.
Whether the defendant's sentence was illegal in light of Murdoch. Here, what we have is a question of whether the defendant's sentence might be illegal
But
based on a factual.
what's the difference between this case and Dickey?
Remind me exactly in what context with Dickey.
Dickey was a motion, whether you can raise a motion to correct a legal sentence for the first time on appeal, which we did.
And I don't remember, to be perfectly candid, if the issue in Dickey was factual or legal. But that would be that's the distinction that I
What's
would
the
draw.
fact here that we're trying to decide?
He is now saying that he may have been convicted of a crime in Arkansas that may not be identical to Kansas
Where we
offense.
do comparable offenses. I mean, we just look at the statutes. There's no facts involved at all. Under 6811, we're just looking at the statutes, right? The elements.
Then I would suggest that this court look at the elements of theft from Arkansas, because that's the name provided. I get there's an error in the number.
How
provided.
do we know that it's an error in the number and not an error in the aiming of the,
Find facts. That's how.
right,
You
but,
do that at the district court. You don't do that here.
okay, so you would agree that, that in the court may remand the case if there is a reasonable question as to whether prejudicial error exists. You agree that we should remand it under subsection D?
I think that is an option if this court can articulate how we get there. Because again, I don't know what is before this court that would properly before this court that would raise a reasonable question at this point. And I think that that's partly why the Court of Appeals did what they did. And they dismissed the defendant's
But
claim
the
because,
Court of Appeals made their decision 2 weeks before this amended statute.
right, they didn't have this, but they also dismissed the claim so that no one can try to come up here and assert claim preclusion. We're not asking to do that. We don't want a decision on the merits here. What the defense seems to be pushing for, and I heard it out of both sides today, that yes, remand it with a set criminal history or remand it for an evidentiary hearing. If you, again, I don't think that we can get there. That lost my train of thought a little bit there, but getting there would require the kind of fact finding that we're saying that can't be done. And part of the problem here that was also evidenced here today is that this court's relying on statements from counsel about phone calls to clerks, phone calls to prosecutors, things that cannot be challenged, things that cannot be questioned.
I just thought we were relying on this district court of Cleburne County document. And then there was
Well,
when
what
you
defense-
challenged that, there was an affidavit saying that it was a true and correct record.
My question to the court would be, how can you consider an affidavit? This statute does not provide you the opportunity to do that, nor is this a fact-finding court.
If we disagree and we find that the documents that were filed by the defendant can be properly considered by the court, are properly considered as they are attached, then does that sufficiently raise an ambiguity such that remand would be?
In that hypothetical, my answer is yes, simply yes.
Is part of the confusion issue here that perhaps what we're really here on are the two motions, not so much the appeal. Have on occasion granted oral argument on motions. Frequency, remand both original actions and motion, fact finding to district courts. We have that procedure.
Right.
So I hear a significant part of your argument perhaps to be focused solely on appellate rules. Are we shifting? Are we really under motion rules?
Not really clear because the defendant's motion is still pending and there's not been an order from this court that would grant argument on that. I can foresee in that hypothetical scenario where the order that would be entered is a remand for an evidentiary hearing at the district court though. And that's coming full circle. Again, every time the answer is an evidentiary hearing.
Well, I'm not sure I'm convinced of that. So let me ask, because the D is fairly, we can take judicial notice. And I assume the legislative contemplation, the legislative intent was that in a lot of cases, our ability to take judicial notice settle the question.
I think in
But there
Kansas,
may be some that there aren't.
yeah, I think in Kansas cases, that's true. This court can always take judicial notice of documents that are filed in Kansas courts.
He doesn't limit it to Kansas courts, does it?
It doesn't express it, but I can tell Your Honor that if you consider the legislative intent, given all the ambiguities here, that was the
That's
goal.
not ambiguous at all. It doesn't, well, actually, I'll rephrase. Point me to the ambiguity.
It's saying in one breath, it talks about in designating a record, the offender may provide journal entries. And that's all that it seems to allow them to present. And but then it also goes on to list all of these additional things that can be looked at. We know that we can look at other things.
I'm just asking, I'm sorry, I thought I heard you say that the judicial notice in subsection D is limited to Kansas documents. And I just don't see that.
I say it's not entirely clear.
Because the last sentence uses verdict forms for Kansas convictions.
Correct.
As
The
opposed
sentence-
to, okay, I'm tracking now. Thank you.
Yeah, you bet. So I heard the question posed, why don't we do something? Why does this take so long? And my response every time is it doesn't have to. We'd be happy to litigate this at the district court. where we can actually have the facts found.
Well, if that were true, why didn't you just agree to go down to the district court?
I'm sorry.
Well, just seem, when is this, when is Mr. Steinert's sentence done?
That's in 2024.
But if we were to rule in his favor, it would still be 2024?
I don't, I can't control this, Your
Yeah,
Honor.
no, it December 2023. I remember it was in the brief. So yeah, if he gets the lower amount, then he would get released this year in December.
Or when it became clear that he wasn't going to succeed on that issue, and the only other issue in his appeal was one that was a core of fact-finding issue that was flatly refuted by prior precedent from this court. Have gone right to the district court then. The defendant could have gone straight to the district court then. And again, I don't know that it's even clear that there's ever been anything that stopped him from going there. And there's certainly nothing that would have stopped him from going there over the last year since at least since July 1st of 2022. Clearly provides him that avenue of relief. So I do want to be clear. We are partly frustrated and confused because we don't know how this works, and because we have to comply with rules that are, at least from our perspective, hampering our ability to resolve this, because we continue to push different arguments at the district court, different arguments at the Court of Appeal, a new statute because things have taken so long when it gets to this court. There is a clean, simple way to resolve this, and it's as the Court of Appeals did, is to dismiss this claim and we can get this resolved. I guess I know I'm wildly out of time, but I hope this has been a fruitful discussion this morning. It does feel a little bit more like law school class than many of the arguments that I've had up here. But that comes with the territory when things are, I guess, a little bit confusing and we've got some conflicts that everybody wants to work out. The final thing, I would cite just one last case to this court, Neal 292 Can 625. This is something that's been going on for a very long time. When there are ambiguities, back then, remand was automatic. And dismissal or remand is automatic. Old CPD cases from the city of Wichita, they've been around for over a decade now. So I think that the avenues for relief here are clear. It's to dismiss the defendant's claim as the Court of Appeals did and allow him to pursue a motion to correct a legal sentence in the district. If there are no other questions, I thank this court very much for its time.
May it please the court, Your Honor. I've got 5 points here. I'm going to try to make them really quickly. First, regarding 6820B. I understand I could file a motion in a district court under 6820B, but that's a bad idea for 5 reasons. 1, I've already started an illegal sentence claim in the appellate court. What happens when the district court rules for me and the appellate court rules against me, or the appellate court rules for me and the district court rules against me? When we have concurrent claims and concurrent courts, you have those dangers. So I would like to take mine through the appellate court. 2, 6822 is permissive. I don't have to do it. I've got a claim going. I want to litigate my claim that's already going. 3, 6814 gives me this option. 4, you don't get appointment of counsel with 6820. My regulations prevent me from working in district courts and doing these types of things. So if we want a whole bunch of pro se uncounseled motions, sure, but let's be honest, that's not what they want. And even if these regulations allowed me to go, I have a statewide practice. Do you want me to go up to Goodland one day, down to Oswego the next day, over to Sedgwick County, and up to Johnson County, all when the state hasn't carried their burden initially? And council knows these things have been going on for so long. It's because the state doesn't carry their burden and no one's forced them to. Secondly, a Cleveland County District Court. Who calls a prosecutor to get a journal entry? Why don't you call the courthouse? Call the clerk. That's who I called. That's how I got mine. That's who anybody calls. So as far as them making an investigation, I don't buy it because they didn't even call the place where they go. And I got a journal entry. I added it. I even talked to the clerk twice, who was kind enough to sign an affidavit proving this is a journal entry. Third, as far as remand of the district court, the state wants to fight this motion to correct legal sentence district court, then they shouldn't have posed my motion to correct the legal sentence in the Court of Appeals that asked for a remand to the district court. I understood I was going to have to get that journal entry and evidence. That's why I asked for the Court of Appeals to remand it to the district court. They opposed it. We could have been done with this a long time ago had they opposed it. Furthermore, they keep on talking about things outside the record and emotions. 602 and 603, those rules apply to briefs only. Rule 501, which applies to motions, says, unless made during a hearing, an application to an appellate court must be made by written motion filed with the clerk of the appellate courts and must state with particularity the ground for the motion and the relief or order sought. Each motion must contain only a single subject. There is no prohibition on attaching things outside the appellate record to a motion like there is for an appellate brief. My motions also don't have table of contents, which 602 and 603 require. They don't get kicked for that.
Could you respond
Mhm.
just maybe briefly to what I understood the state's argument to be toward the end, that 6814D is intended by the legislature to apply only to in-state?
No, absolutely not. The court can take judicial notice of only Kansas convictions, but we're allowed to supply journal entries, others. I think the court wanted them to take notice because, again, there's not going to be much dispute over Kansas journal entries. Those are easier to get. And that's why there's a provision. Had they want to dispute my journal entry, they can get a journal entry
How,
and add it via 501, which doesn't have provision.
outside the
Yeah.
context of this case, just looking at the
Yeah.
statute. If we, the appellate court, are not taking judicial notice of the document that gets filed, what are we doing?
And again, I'm not exactly sure, which is why when I filed my motion to correct an illegal sentence, I asked for remand. So the district court could do this, right? So they could take evidence, they could have the exhibit, enter into evidence, and it would be appealed back up to the district court as part of the direct appeal, right?
So you're not, again, this is helpful for me
Yeah.
at least, because I had understood all along that you were asking this court to take judicial notice of the Arkansas document.
Well,
But now it sounds like you're not asking us to do that.
I don't know. I think you can, and I think the way this, I think by judicial notice, I don't know if the court meant that they could take judicial notice without actually having to present it, like the court, like, let's say the prosecution say.
Judicial notice is a term of art that
Sure.
means accepted as true.
Right,
factual.
but could you take judicial notice of the conviction? And again, let me look at that particular language, because I always read that third sentence in there as going, the court may take judicial notice of such journal entries, complaints, and plea agreements, and jury instructions and verdict forms, Kansas convictions. Now, again, I don't know what you're going to do with the ones that I provided, because
Well,
I don't
so
see
let
the
me be
difference.
concrete on that.
Sure.
You provided an Arkansas document.
I provided
or a
an Arkansas journal
document
entry.
That on its face purports to be
And that was,
right.
Yeah.
Are you asking us to take judicial notice of that document?
I am asking you, I guess if that is a term of art, and I don't know if the statute allows that, it may need to go back for
Oh, and
that.
that was gonna be my follow-up.
Sure,
If
but-
the answer is yes, is the legal foundation for that subsection D or something else?
Subsection D. Oh, well, and also, I do think independent of subsection D, I could do this under 223504 under the anytime and the motion, because again, a motion is not controlled by Rule 6, so I don't have to pull from the appellate record. I can attach other things, which is what you do with the motion, which is what exhibits are, right? I mean, that just makes sense.
If you're asking this court to take judicial notice of a journal entry, defense had the opportunity to object.
They did, and they had an opportunity to add, but they haven't. Because they just won't, they just won't. What they want to do is they just want to throw up bricks to me, trying to correct my client's illegal sentence. Oh, well, he stipulated. Well, we can't correct it here. Oh, well, you got to file there. Oh, well, that's not really journal entry. Where is the compassion for this person who is potentially spending almost a year too long in prison?
Well, my compassion isn't going to allow me to throw out the code of evidence.
No, but when you have a statute that says I can add something and you can determine something on a preponderance of evidence, if that's, I don't see any distinguishing factor between taking judicial notice, but the statute clearly allows it. So if we want to call it that, sure, that's fine.
Well, isn't there a difference between a statute that allows us to look at something to determine whether or not I have a question that it may have been done inappropriately, as opposed to taking a different view of that document, accepting everything is true and making without other input, and then making a fact finding based on that.
There's a couple things. The only lack of input here is the state's refusal to play, is the state's refusal to add it. But, and secondly, that last sentence says if there's a reasonable question, if there's no reasonable question, as there is in this case, because we can't tell, and if we can't tell what he's convicted of, we can't do the comparability analysis. And so if we can't tell, that's a legal sentence. So no, this case doesn't need to go back because of that last sentence. It's not a reasonable question. There is no reasonable question. It definitely exists. It's here. So I was saying, no, you only goes back for it if there's a reasonable question. But here, since there's no reasonable question, this court can say, no, look, the preponderance of the evidence. And again, to the extent that 6814 allows this court to do fact finding on appeal where they priorly couldn't, I don't see why the legislature wouldn't allow that. Why not? If you're going to allow me to add things, and then we're talking about preponderance of the evidence, what else are we supposed to take from that? But one last portion I want to meet, and I apologize, but counsel says that it's clear that the theft was Arkansas. 5-36103, theft of property. 5-36104, theft of services. 5-36105, theft of mislaid or delivered by mistake. 5-36106, theft by receiving. 5-36107, theft by trade secret. Again, subchapter 1 of chapter 36 is called theft. It lists a whole bunch of crimes, very different crimes. So there is no one theft. And without knowing what he was convicted of, we can't review his sentence. And I can't tell, and that makes it ambiguous, which makes it illegal, which demands relief. And therefore, we'd respectfully ask this court remand to the district court with criminal history I, since that's the only evidence we have by preponderance evidence, the state hasn't provided any, for resentencing out of criminal history I. I have no more prepared remarks.
Questions? Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement. That completes the docket and court is adjourned.